Good afternoon, everyone. I'm opening the meeting of the Platting Board here at 1:01 p.m. Madam Clerk, the roll, please.
Plotting member Shavetta.
Present.
Plotting member Liebing.
Present.
Plotting member Gilson.
Present.
Plotting member Salmon.
Present.
Plotting member Traxler.
Present.
Plotting member Krieger.
Present.
Plotting member Burtz.
Present.
Madam Chair, we have a quorum.
Thank you. Can we stand for the pledge, please? Okay, are there any objections or changes to today's agenda? Seeing none, can I get a motion to approve?
I move to approve the agenda for the July 17th, 2025 meeting.
Thank you. Can I get a second?
Second.
Thank you. Are there any changes or objections to last meeting's minutes? Seeing none, can I get a motion to approve?
I move we approve the minutes from the July 3rd, 2025 meeting.
Second.
Thank you very much. Okay, I'm going to open public testimony for persons to be heard, present or online, for items not scheduled for public hearing. Is there anyone present that would like to testify? Anyone online? Seeing none, I'm closing public testimony. So for unfinished business, we have Cooper Woods Phase 2, Lot 16B, Block 1. The request is to vacate a portion of right-of-way on Lot 16A, Cooper Woods Phase 2, Lot 16A, Block 1, and 8A, Block 2, to be known as Cooper Woods Phase 2, Lot 16B, Block 1. The property is located directly south of East Gemini Lane and directly west of North Kavanaugh Circle within the northeast quarter section 9, Township 18 North, Range 01 East, Seward Meridian, Alaska, in the North Lakes Community Council and Assembly District Number 6. This case was continued from the June 5th, 2025 Platting Board meeting. Ex parte. Do you or any member of your immediate family have a substantial financial interest in any property affected by this decision, or will you recognize a foreseeable profit as a result of this decision? Seeing none. Have you received or otherwise engaged in an ex parte contact with the applicant, other parties interested in the application, or members of the public concerning the application or issues presented in this application, either before the application or during any period of time the matter is submitted for decision outside of the public process provided by the borough? Seeing none, are you able to be impartial in this decision? Seeing an affirmative, Madam Clerk, mailings, please.
There was 102 public notices mailed May 13th, 2025.
Thank you. Staff report.
Thank you, Chair. Chris Curlin, Platting staff. The proposed right-of-way vacation is on the eastern boundary of Lot 16A, located directly west of North Kavanaugh Circle. The petitioner proposes vacating the western 2.23 feet of the right-of-way pursuant to MSB 431065G. Petitioner has provided an affidavit of posting of the public notice of vacation of the right-of-way. That's in your handouts. A legal description, a scaled drawing, and the location of the right-of-way to be vacated. Pursuant to MSB 431535B1CB, a dedication to public use of land or interest in land may be vacated if the dedication is no longer necessary for present or future public use. The Platting Board shall review applications for vacation as follows. 1, the Planning Board shall ordinarily approve vacations of public right-of-way if the vacation is conditioned upon the final approval of a plat affecting the same land, which provides equal or better access to all areas affected by the vacation, or the surrounding area is fully developed and all planned or needed rights-of-way and utilities are constructed, or the right-of-way is not being used, a road is impossible or impractical to construct, and alternative access has been provided. Planning staff notes that the right-of-way is constructed and is being used. A comment was received from MSB Pre-Design and Engineering objecting to the vacation as proposed because vacating this right-of-way would result in a substandard cul-de-sac. A second comment was received from PD&E, it's in your handouts, that if this was approved, they would like the snow storage easement to remain. Instar and GCI have no comments, recommendations, or objections. MTA and MEA did not respond. There were no comments received from the public. Staff has provided findings for both approval and denial for the board's determination. Thank you very much.
Thank you. Any questions for staff?
In the application, what is the reasoning for? I failed to see the reasoning why we're looking to vacate this.
I believe it's a setback issue from the edge of the right-of-way.
So it's the housing setback or the deck setback?
I believe it's the house, could be the deck. The petitioner's representative might be able to clear that up.
Any other questions? Okay, seeing none.
Through the chair.
Oh, sorry.
I guess I'm a little confused where it says we would ordinarily approve vacations of right-of-way if, and then down here, the right-of-way is not being used, but the right-of-way is being used. So, I don't know. I don't see the language here where it says, staff recommends approval of this like it usually does. So I guess I was just wondering, is it approvable if it's being used?
The way I understand it, we can't recommend if it's, it is confusing. I agree with that.
Go ahead.
So is there an alternative to satisfy the setback? Could they get a variance on the setback without making the cul-de-sac not to borough specifications? I mean, is that an option besides vacating this, that there could be a variance for the setback?
I can, Madam Chair, I can speak to variances.
Okay.
Okay, my name is Alex Strawn. I'm the planning director for the Matsu Borough. Variances are handled under MSB 1765. It's a special section of code they're approved by the Planning Commission. There are 5 criteria for variances. I do not believe that this would meet the criteria of a variance because they have plenty of buildable land on their property. You'd have to have some sort of circumstances like it's sandwiched between a lake and a right-of-way and it's a small lot, or like a cliff or something like that. I don't think that this would, in this case, qualify for a variance. Now, ultimately, that would be up to the Planning Commission, though.
Thank you, Mr. Strawn. And Amanda?
Do we know? It says, one of the comments that we would be creating a substandard cul-de-sac. And I guess my question is that because the snow storage easement goes away too, unless we keep it there? Or what makes it a substandard cul-de-sac? Just size constraints? Or do we need that snow storage, I guess?
I believe a cul-de-sac has to be 60 feet in radius. So if we flatten out a portion of that, we lose that radius, that small little section. I have a question. Why is it that the 22.8 feet is an issue right now? Is something causing, are we trying to sell? Are we trying to, I've seen before that we just accept that it's 22.8 feet as long as the HOA is not complaining, or, you know, where's the complaining coming from? Do we know?
I don't have an answer for that. The petitioner's representative would be the one.
Seems like all questions would be directed to the petitioner. Okay, so we're done. Okay, would the petitioner or the petitioner's representative like to speak right now? Right? You'll wait? Okay. Okay, so I'm going to open public hearing for 3 minutes for anybody that would like to speak here or online. Anybody online? Okay, seeing none, I am closing public testimony. Now, if the petitioner's representative would like to speak.
Good afternoon. My name is Craig Hansen, representing the petitioner. A little background. Some builders whom I don't remember their names built this house. And in curved boundaries, it's not uncommon to miss it. And they did. So instead of 25 feet setback from the right-of-way, they're 22.8. So there it is. The house corner is within the setback. My client, Mrs. Levine, buys the house. At that time, this was a couple years ago, they said they'd take care of it, and they initiated this process to get the variance. This has been dragging on, but here we are. And so what is being asked, to back up to the question of who cares, which was posited here by somebody, primarily the owner. You know, she's got a house now that's in violation. It's violating the setback ordinance. Right now, that's not a problem, but it could be if she goes to sell it and the bank doesn't want to lend money on it. So it does kind of create a cloud on the property itself. With regards to how these things work, this is not at all uncommon. As it was mentioned, it'll create a non-standard subdivision. Well, this happens. And if it was on the straight stretch and we had a 60-foot right-of-way, and we carved out a little spot and changed it into a snow storage easement, we'd have the same circumstance. It would create a non-standard right-of-way. So that's the issue at hand. The snow storage is something that we create in lieu of the area that's actually in the right-of-way. So now if you imagine, right now what's happened is in the curve, there's about a 32-foot long stretch from zero at either end, and at the middle, it's 2.5 feet large, all right? So we're talking about a rather small area. And so what is proposed to do, and I said it's not uncommon, is to, well, let's just take the boundary of the right-of-way, move it in that 2.5 feet right at that one point, and then feather it back out to zeros, and then take that area that we've lost and give it back to the borough in the form of a snow storage easement. So, in the end, the use isn't modified. They can still use it and do whatever they need to do. And I can answer any other questions right now, if you've got any technical questions. And then Ms. Levine is going to get up and speak as well.
Question, if you will. I understand the dilemma, and I feel for the dilemma. The point is, at what point, I know it's only 2 feet, but at what point is the boundary, if it was 8 feet, 10 feet, whatever? I guess my point is, there's going to be no changes to the road. It's just a line on a piece of paper. Is that correct?
That is
Ultimately?
correct.
All right, thank you.
Oh, if there was a question buried in there, what I would say,
I apologize. I guess I'm talking out loud, trying to work the problem through my head.
perhaps I'm still on my own time. The question arises of, golly, where is the line? What if it was 2.7 feet? Should we give them the variance? Well, the reality is most all the stuff that we do here, we come before you and it's a done deal because we've met code. And what it is for you guys to decide, there's not a whole lot there because it meets code. But this is a case where it does matter. You guys, it's up to you to say, is this one of those areas where we should make an acceptance? And that's exactly what your role is. That's all I would say about that.
Mr. Levine?
I had a question regarding the issue of the deck that it is alleged was constructed between May of 24 and February of 25. First of all, I'm not sure if you have knowledge of that and whether or not, if in fact it's also an encroachment, is this change in the outline of the cul-de-sac going to cure that encroachment as well?
So the short answers are yes, I'm aware of that because you can see the second as-built there that I signed. We went out and surveyed it and found that they did indeed put the deck out there. The current issue at hand is for the house, 22.8 feet. What they'll have to do about the deck after that, that's a separate issue. Whether or not it's decks, see, buildings are for, setbacks are for buildings. And I honestly cannot say as to whether or not the deck would have to be moved. But in this current case, I would say it's a non-issue because we're talking about the setback for the house because they obviously don't want to move the house. If the deck was built in violation, I rather doubt that you would want to, change things to accommodate the deck anyways.
Thank you, Madam Chair. This is Alex Strawn. Again, I think there was a little bit of misinformation here. So 1755, which regulates setbacks from rights of ways, which is what we're looking at right here. Decks only count as a structure for purposes of setbacks if they're above 18 inches above grade. I don't know if that's the case with this one right here, but that would be, if we ever go to enforce or something like that, that's what we'll be measuring. So.
Any other questions? I have one. So would this in any way affect how snow is removed, how they plow the snow in this cul-de-sac?
It would not because, the borough's rights to put snow here, there, or the other where is not changed.
So there's not going to be someone calling complaining that there's a pile of snow on their property where it shouldn't be.
They might complain, but it won't be because of this. Like I said, we're talking
That's
about.
my main concern. I mean, it seems like the cul-de-sac is designed where it feathers out to the right onto this property, and it looks like the ditch is wider from the aerial photo. So I'm assuming that the plow, dumps the snow more maybe on that property.
Yeah, I can't speak to that exactly. The reality is the boundary line itself, it's beyond the ditch in any case. When we build these, unless it's a tremendously deep ditch, even by the subdivision construction manual, we need to come daylight with the back slope of our ditch 5 feet from the right of way. So we're not talking about an area that's in the ditch, even within the shape of the ditch. We're talking about an area that's beyond that.
Okay. Any other questions?
If my time is not up, Mary Lou would like to speak to this.
Okay, thank you.
My name is Mary Lou Lavine, and I'm here today as the owner of Plat 2022-134 in support of the request to vacate a portion of the right-of-way on what is known as the Cooper Woods, Lot 116B, Block 1, tax ID number 833-481L016A. I'm just asking your consideration and passage of this vacate request from the Platting Board, and ask your consideration and passage of the vacate request for the Matsu Borough to vote on it. Thank you for your time.
Thank you for your testimony.
I'm sorry?
Thank you.
Oh, you're welcome.
Seeing no questions. Can I get a motion from the board? Oh, are we speaking again? We are not. Can I get a motion from the board?
Madam Chair, I make a motion to approve the vacation of 2.23 feet by 32.44 feet, portion of the public use easement vacation, Section 19, Township 18 North, Range 01 East, Seward Meridian, Alaska, contingent on the staff recommendations 1 through 7.
Thank you, Mr. Liebing. Can I get a second?
Second.
Thank you, Ms. Salmon. Discussion? Any discussion from the board? Ms. Salmon?
I think I just want to make sure I got that wrapped up in my head right. It just sounds like we can get the primary improvement, the house, into a acceptable standard without losing the use of the cul-de-sac or the snow dump. And so I guess I would be okay with that if that seems to be the case, if that's everybody else's understanding of it. Sorry, one more thing. I think, and Sandra might back me up, in a financing scenario, like if the bank was gonna not lend on a house like that, we could rip that deck off and the buyer could put it back on later. That's what we would do.
More discussion to help me the way I'm going to vote. At what point do you start saying no to these? You know, I realize it's only 2 feet, but it's making the cul-de-sac out of compliance. What if the next one is 8 feet, 10 feet, 12 feet? That's my dilemma. And if anyone could sway me another way in this discussion, I would appreciate it.
Mr.
In my
Liebing?
experience with things like this, as a realtor with a client with this, I believe the only powers that be that had a problem with a small setback was an HOA. And I called the borough and said, do you have a problem with this setback not being 25 feet? And they said, no, that falls out of our jurisdiction. It was the HOA that had a problem with it. And so we had to get a letter of, we don't have a problem with this, from the HOA. And if I remember right, it's been a couple years, but I mean, the lender didn't mind, nobody minded anything. I just feel I'm in agreement with you that we don't need to set a precedent saying that, oops, your house is in the setback, we'll fix it for you. I don't like setting that precedence. It was very simple. It was a very simple fix during the transaction, and I don't think it was a lending issue whatsoever.
Mr. Liebing?
I appreciate both these comments, and Chris, I think you bring up an excellent point. But for me, what I am looking at is, does this change negatively impact the neighborhood or the immediate property owners in terms of their ability to use the cul-de-sac? Does it change the traffic patterns? Does it have any physical impact on anyone using this subdivision? And when I look at this, and with the explanation provided by Mr. Hanson, I can't see where it has any impact whatsoever. There's no physical change to the cul-de-sac. There's no physical change to the roadway. It's simply creating a sliver that used to be called right-of-way. It's now a protected zone that can't be used for anything other than the snow. And so in my opinion, this is a minor technical change that will benefit a homeowner without making any impact to the neighborhood or the neighbors.
Thank you, Mr. Levy. Did you want to say something too? You said it very well. Okay.
I don't see how this impacts the homeowner the way it is now. From my experiences, I don't see how it's negatively impacting the homeowner or any future homeowner at this time.
Mr. Strawn.
Thank you, Madam Chair. I did just want to address the comment that the borough said this is not in their jurisdiction. I would disagree. The borough does care about setbacks from rights of ways. This is within the borough and would be within our jurisdiction. So, it's although it's unlikely that we would, start issuing citations on the daily basis, we could. And at any moment, the assembly could say, we want you to really hammer down on rights of way setbacks and rights of ways. So, I think, I guess, I don't want to try to sway you one way or the other. I would say that this right of way at this area is probably only being used for maintenance and snow storage. And so, if this were to be vacated, it would continue to be used for maintenance and snow storage. Just going back to the original question of, the standard that is this right of way being used. And right now it's sort of being used for maintenance and snow storage. So.
Well, looking at here at MSB 43-15035, and we go all the way down to A, the surrounding area is fully developed and all planned where needed rights of way and utilities are constructed. Is the lot next to it, are the utilities constructed? So according to how I'm reading this right now, if that utility is not constructed, there's only one answer. So are the utilities constructed for that lot next door? He's saying yes.
Okay. Mr. Hanson, can you speak at the microphone, please?
So the question that you brought up was about utilities and whether or not they're in. When we do these subdivisions, we put a 15-foot utility easement on the outside of the right-of-way. And within that easement, within that utility easement, we place the utilities, the electric and the phone. And all of those go in at the time of the subdivision construction. So then the utilities are, in fact, all the way around the subdivision, all the way around the cul-de-sac. Regarding the specific lot, couldn't tell you. But what they do is they tie in and just go straight back to the lot, so they wouldn't be impacted. The utility easement that was necessary was already provided. The utility easement that's necessary and being used is not impacted by this action in any way.
Is there any kind of sidewalk platted in for this subdivision?
No sidewalks.
Thank you, Mr. Hanson. Any further discussion? Personally, I find this difficult too. I don't like the idea of letting that easement go or the right-of-way go. It bothers me. I don't know, there's too much of it. There's people that take advantage of that or make mistakes, and I think people should be more careful about where they're situating the house on their lot in the first place. Yeah. Amanda?
I think back to what Sandra was saying, where, it doesn't look like an issue necessarily today, maybe not an issue to a lender later. I guess my concern would be, if we were to vote and close this case, it's probably not a problem today until you get ready to sell. And if a lender has an issue, then it's a problem that they probably request this solution for. I would assume, rather than moving that house. And so I guess my thoughts are, can you leave it open indefinitely for 10 years or whatever until potential sale comes up and a lender has a problem? Then all of this is ready and the fees are filed. I guess that's, I mean, if you close it today, then it's done. If we say no, it's no. If we say yes, then the house is okay. But it doesn't sound like we're going to go for a yes. And so that would be my thoughts, is if you, I don't know, can you table something indefinitely here?
Mr. Kirk. Matthew.
Thank you, Madam Chair. Matthew Goddard, Platting Technician. According to our legal department, we cannot table cases to a date uncertain. We have to choose a specific date we are continuing a case to. So it's either approval, denial, or continue to a date certain, basically, that we're looking at.
Thank you, Mr. Goddard.
Question or comment. If we were to approve this today, the borough always holds the right to claim eminent domain if they need that curve put back in. We approve it for now. If the borough someday decides that they don't like that there's a flat spot in that cul-de-sac, we approve it, we get it cleaned up, the builder made a mistake, and we move forward. I mean, it's like you were saying, it's not hurting anybody or anything, as long as the snow removal's still good and the utilities are good and everybody's happy. What's it hurt to flatten out this cul-de-sac? If it ever becomes a problem, the borough comes back in, claims eminent domain, and it goes back to 22.8 feet.
And I think at that time, the borough could say it's not a violation and give the house a variance too, if they had to take that back and it was a setback violation.
Mr. Strawn.
Thank you, Madam Chair. I think a variance is unlikely, like I said, and I'm not an expert in laws regarding eminent domain, but I think generally that is reserved for larger arterial or major collector type projects and not on small little subdivision projects. I don't think the borough would ever take this for eminent domain.
Thank you. Any further comment? I'm on the fence too. I think it should be left alone, personally.
Through the chair, I think the question for me is, what do I like less, right? Like, do I like a violation, just getting a handout and a pat on the back and no problem? I don't love that. But do I love the government taking more land than we need for no reason? No. I don't like that more, right? If we don't need it, if it's working the way it needs to work, then I think we should let it happen and let the gal not have to worry about the value of her home in the future. And like you said, we're not talking about a speedway here that we might have to take back later either. It's a little cul-de-sac there. So I guess that's what I'm weighing. How do I like giving, variances or what are we calling this? Whatever we call that. Do we like letting people break the rules and get away with it later? No, not really. But if we're talking about 2.5 feet of dirt that we don't really need, I don't like the idea of putting my thumb down on somebody. I like that idea less, I guess is what I'm saying. So I would still probably vote in approval of this. The reason I asked about sidewalks is because I had seen one in Settlers Bay. It had to be moved. The HOA required it because they had a sidewalk platted in there. And so it wasn't even a borough thing. It was the HOA said you're not okay, and they actually moved the house and it had value. So that can be done, but we don't have anything like that here. So that's my input, I guess, is I just don't love any entity taking what they don't need from a private person. That's it.
Madam Chair.
Mr. Levy.
I guess I would just want to make sure everybody understands that the borough's not giving up this land. They're not ceding it over to private property. They're simply redesignating it to a different borough ownership title. And the borough will continue to retain it, and there's no physical changes. It's really just from moving a small piece from what's called a right-of-way to a small piece, which is the snow storage area. It's still borough property. It's still in borough control. It's not like we're giving up land to a private owner.
But once again, I'm still trying, I'm sorry, keep circling around. At what point do we draw the line? Is the line on a proper cul-de-sac? Or if this was 8 feet, would we be having this much, 20 feet, 15 feet? To me, the line has to be to have a borough compliant cul-de-sac. And if I vote yes, I'm making the cul-de-sac out of compliance. Yes, it's only 2 feet, but 2, 6, 8, 10. There's got to be some line, is my point. I guess, we could keep going around circles. We've got to vote at some point.
I would, if I could, respond to that. It looks like the next case would be a much more significant thing, right? Like you got a bunch of lot owners that back up to that and potential access that could be used. So not to go too far off base, but I just don't see this one getting utilized like some other cases that come up to us. Yeah, having no sidewalks, no need for utilities. I don't know. I guess that's where I think there are definitely bigger cases that would come up that would be very clearly, I don't know, other people are going to use that,
Well, we have the lawyer here now. Mr. Ashenberg, I don't know if that's what
John
your name.
Ashenberg, Deputy Borough Attorney. I saw some comments earlier, and I just wanted to clarify a couple things. So first of all, I think the Planning Board seems to understand this is a legislative function. You're not doing a quasi-judicial one. It's subject to veto by the Assembly. And so you're really wearing a different hat today. And there's guidance in the code, but it isn't one of those situations where somebody can say, or I mean, obviously anybody can say anything, but can make the argument that, hey, if they meet the code, it's a quasi-judicial decision that you have to approve it, and then it's subject to appeal to the Board of Adjustment and Appeals in the Superior Court. This is different. You're wearing a legislative hat. So think of the idea of vacating a public park. The court is, and the BOA is not really the appropriate decision maker. So you're doing an analysis which makes sense. The comments about, well, do we need this in the future? Is the borough going to have sidewalks around this cul-de-sac? So, I think that you're wrestling with the appropriate considerations as to whether or not a keyhole vacation of this cul-de-sac is appropriate, and sort of looking at, well, what would the Assembly think if this, if you approve it, then it goes before them. Is this appropriate? I think the other part, there was some suggestion that a motion to continue would be inappropriate. I think staff was attempting to answer a question, but not understanding this is not a plat. So the requirements for reviewing a plat and certain timeframes don't apply. So you could move to continue this indefinitely to have, in essence, the effect of denial. But there's no mandatory time frame. Just so just to keep those things in mind. It's not quasi-judicial, it's legislative. You do have an objection, but from my reading of the report, Public Works has said it's an awkwardly worded thing that they don't like the substandard cul-de-sac being created. And it's true, you've brought up, that this isn't a cul-de-sac, it's not a straightaway, but correct me if I'm wrong, I thought Public Works was saying they don't think this is appropriate by creating a substandard cul-de-sac. So anyway, I understand you're wrestling with a tough issue, and where do you draw the line? But I appreciate the opportunity to speak. It's a tough one. I don't know, staff has been a little on the fence on this, but, you look to them for guidance. In the long run, should we be vacating rights away when people build in violation of code?
Thank you, Mr. Ashenberg. Further discussion? You should probably call the roll on this, maybe. Okay, Madam Clerk, the roll, please.
When I call your name, please tell me how you vote. Plating member Shavetta,
No.
plating member Liebing,
Yes.
plating member Gilson,
Yes.
plating member Salmon,
Yes.
plating member Trexler,
No.
plating member Krieger,
No.
and plating member Burtz.
Yes.
Okay, we have 4 in favor of yes and 3 no's.
The motion has failed. It's passed? Oh, my apologies. I thought it was-
Just to clarify, plating member Shavetta voted no. Plating member Traxler voted no. Plating member Krieger voted no. Plating members that voted yes are plating members Liebing, plating member Gilson, plating member Salmon, and plating member Burtz.
Thank you, Madam Clerk. Okay, the motion has passed. On to the next one. Where am I? Okay, we have no reconsideration or appeals. Our next hearing is the Davidson public use easement vacation. The request is to eliminate the 50-foot public use easement on the southern boundary of tax parcel B3. The property is located south of East Texel Drive, east of North Ingstrom Road, north of East Wolf Creek Road, and directly north of North Crested Butte Drive, within the northwest and northeast quarter section 15, Township 18 North, Range 01 East, Seward Meridian, Alaska, in the Fishhook Community Council and Assembly District Number 1. To the board, do you or any member of your immediate family have a substantial financial interest in any property affected by this decision, or will you recognize a foreseeable profit as a result of this decision? Seeing none. Have you received or otherwise engaged in ex parte contact with the applicant, other parties interested in the application, or members of the public concerning the application or issues presented in this application, either before the application or during any period of time the matter is submitted for decision outside of the public process provided by the borough? Seeing none. Are you able to be impartial in this decision? Seeing an affirmative, Madam Clerk, the mailings, please.
There was 123 public notices mailed June 25th, 2025.
Thank you. Staff report.
Thank you, Chair. Chris Curlin, Platting Staff. The proposed easement vacation would remove the 25-foot setbacks on each side, creating usable area for the surrounding lots. Pursuant to MSB 431065G, petitioner has provided an affidavit of posting of the public notice of vacation of the easement, handout number 1. Pursuant to MSB 431535B1, the Platting Board shall ordinarily approve vacations of public rights-of-way if the right-of-way is not being used, a road is impossible or impractical to construct, and alternative access has been provided. Legal and physical access to the existing lots required pursuant to MSB 432100, access required. Physical and legal access requirements for the lots are currently met and will not be affected. Petition to eliminate the easement was submitted. That's Exhibit B. The petition included signatures from property owners affected by this action of the 17 lots on the southern boundary of the PUE. 12 petitions were received, 10 were verified as owners of record, and 2 appear to be residents. MSB PD&E commented, if the subject 50-foot right-of-way is found to be invalid, PD&E has no objection to the vacation. MTA requested an easement for their facilities in the proposed vacation. This is condition number 4. There was one objection received after the report was written. It's from the owner of Lot 18 and is in the handouts. After this report was written, we discovered the OSHP status of this easement was not included. We have included it, handout number 5. It shows it as a minor collector connection to Ingstrom. The vacation of the public use easement granted on tax parcel B3 is consistent with state statute and borough code. All lots affected by the vacation have legal and physical access. A majority of the property owners affected by the PUE have signed petitions in favor of the vacation. Staff has provided findings for the board's determination. Thank you.
Thank you. Questions?
Yeah, sorry. The lots to the east and the west of the subject property, do we receive anything back from them?
I did not receive anything from the east or the west.
Are they currently occupied or is it vacant land?
I would have to go off aerial imagery to make a guess.
Do we know? I think it said somewhere that this is the ag parcel. Is that right? Agriculturally bound. Okay. Are the adjacent, like the east-west, are those ag parcels too? And do you think, are they okay with the vacation? Also, one more thing for the staff. Texel Drive here is supposed to connect eventually, isn't it? From like Engstrom to Palmer Fishhook? Is that what I'm trying to say? Because I think we vacated that little lump that's here so that that can connect at a couple years ago.
I can answer that if you'd like me to.
Mr. Strawn?
Yes, thank you, Madam Chair. Texal was approved by the voters as part of a transportation improvement program package, and I believe is funded and moving forward with design. And I think they're finishing up the right-of-way acquisition, but they're they do intend on expanding that in the next few years here. You're going to see that construction happening there. To the north, Texel, I don't know if it's a major or minor collector, what classification it would be, but I mean, I guess I would be remiss if I did not say that this East Farm Meadows Avenue, as Mr. Curlin pointed out, is identified on the official Streets and Highways Plan, which is an officially adopted plan as part of the comprehensive plan as a thoroughfare there and connection out east to Palmer Fishhook. That was not recognized until sort of the last minute, mostly because Fred was fishing and I'm here. But I think that would require some serious consideration by this board if you're to vacate that. So yeah, the official Streets and Highways Plan has a connection going from Ingstrom Road all the way out east to Palmer Fishhook Road. This portion right here that's being proposed to be vacated is listed on there as a non-constructed but in connection that's identified that's necessary. So
Thank you, Mr. Strawn. Mr. Ashenberg.
John Ashmetter, Deputy Borough Attorney. So again, like the last case, this is legislative. You've just heard from the planning director that it's on the official highways and streets map. But I didn't hear whether or not there's an objection. So it sounded implicit, but perhaps staff could put on the record whether they object to this proposed vacation of an important, at least by the Assembly's adoption of the official highways and streets map, an official corridor that the Assembly has adopted.
There was an objection by PD&E. If it was valid, if the easement is valid, they objected. If it wasn't valid, they didn't object, if I remember correctly. Is that right, Mr. Strawn?
I can't speak for PD&E. I know that they said if it's not valid, then they don't object, which implicitly is if it is valid, then they do. I will say the official recommendation of the planning department would be to not approve this as it is a recognized important connection in the official Streets and Highways Plan.
Thank you, Mr. Strawn. So, Mr. Curlin, this is a valid easement, correct? I mean, this is a PD&E thing. I'm looking for the comment.
It looks like with the last minute handout we got is showing deed dedicating right away
Yeah.
dated 1981.
John Ashmetter, if I might, Deputy Borough Attorney. I raised this this morning that I had not seen this recorded document. So whether or not this thing is valid, I don't know, but it was recorded some 40 years ago. That would perhaps take additional work, but what you have before you is a proposal to vacate whatever public interest in this document that the borough has. And so whether or not it's valid, you've got an objection by the planning department on behalf of staff. The Assembly has adopted an official highways and streets map recognizing this corridor, and you're wearing a legislative hat. What is your recommendation and decision here that will go to the Assembly? Do you respect what they've done? The official highways and streets map that's been adopted as part of the Matsu Borough Plan, comprehensive plan? I guess my My 2 cents would be, you've got a valid objection by the planning director. The assembly has spoken. I would respect the assembly's decision, but I leave it in your hands.
Thank you, Mr. Ashenberg. Any other questions or comments for staff?
Can we get an answer on whether this right-of-way is invalid or valid? Because that's going to determine whether we approve this or not.
John Ashman, Deputy Borough Attorney. Ultimately, whether this is valid may necessitate filing a lawsuit to get the court's blessing of it. I would not assume it's invalid. So my 2 cents would be that the borough not give away a valid public use easement that may be beneficial for the official highways and streets map. So I would not assume it's invalid. And ultimately, going and expending a considerable time and expense to litigate whether or not a 40-year-old recorded right-of-way is valid, well, that's an important question. It's not one that I make. My boss would make that decision, but I would not assume it's invalid.
Thank you, Mr. Ashenberg. Any other questions or comments from the board? Seeing none, would the petitioner or the petitioner's representative like to speak?
Hello, Platting Board. Tim Carmen with Bull Moose Land Surveying, representing the property owner. As far as the validity of the easement we'd like to speak to, there's actually 2 documents that were recorded on the same easement. The first one was book 248, page 866, stating that it would be dedicated from the Goodwins to the Cadens, which neither one, looking at the chain of title, ever had ownership on these properties. And that's where the invalid part of it comes from. And they were dedicating it as a public road easement. And then later in book 257, page 334, they change it, or attempt to change it, to a private driveway easement not to be expanded to a public dedication. So they recorded it as public, then they re-recorded it as private driveway easement. But in either case, they had no ownership of the property. So someone that doesn't own property cannot dedicate easement on a property. So that's where the invalid part for that the PD&E was looking at. So the other point I'd like to point out is that this is all agricultural land. There is no plans for development past agricultural land. I believe as well to the west and east that the easement that the easement runs through. So the use for it, it would just simply, if the borough has it as in the road plan, would just simply be a through street, but there would be no development or additional homes in the future plans for the properties. So.
Question. Oh,
Go ahead.
so you say that neither the Goodwins nor the Cadens ever owned this particular strip of land. Who did own it at the time, and how did this come about if neither of these families owned this piece of land?
The petitioner himself may be able to answer that. I don't have the channel title myself, but in the channel title, they are never mentioned as owners. So that may be a question he can answer when he comes up.
I have one question. Is this land locked up in a farmland trust?
That I don't know. Is it in a farmland trust? Is it in a farmland trust? No.
Okay.
Yeah.
Thank you. Any other questions? Okay, thank you.
Yep.
Mr. Ashenberg?
John Ashman, Deputy Borough Attorney. I just want to make a point that it's not up to the Platting Board to decide whether this easement is valid. They can file a lawsuit and go figure it out in court. What this board is being asked to do is vacate what public interest may exist across this property based on this deed of a right-of-way. If it's invalid, they don't need to come to this body. They can go file a lawsuit. What they're asking you to do is vacate what public interest exists across this land based on this document. Usually what you're looking at is vacations of right-of-way that have been created by a subdivision, or, as in the last case, the right-of-way created for the cul-de-sac through a subdivision. So what you're being asked to do is vacate a document creating a public, ostensibly, creating a public right-of-way that was recorded at the recorder's office. So keep that in mind. Whether or not this thing is valid is not before you. What they're asking is, hey, should the borough, if it has a public interest through a recorded document, should it get rid of it? And I think the assembly has answered the question in terms of, is this swath of real property needed for a future road corridor? And one of the criteria for determining whether or not you should approve the request to vacate an interest in real property is vacate an interest of a right-of-way is the future need for that particular area. So if you consider that, I think the assembly has said, in essence, yeah, there's a need for a future right-of-way in this corridor. Now, if they really think it's invalid, they can go file a lawsuit and get a judge to say it's invalid. But that's not before you. So if you did decide it should be vacated, I would urge that language be used that the borough is vacating what interest, if any, it has in this right-of-way. But again, you've got an objection of your planning director. The assembly has said this corridor is important for future roads. So I leave it to you. Thank you.
Thank you, Mr. Ashenberg.
I feel that we need to clarify whether this right-of-way exists or not before we place judgment on whether to vacate it or not.
We can't do that.
I mean, I think it does.
I think we need to.
It exists.
Point of order,
It's there.
I think we need to have a motion on the table before we should have a discussion.
Okay. I'm going to open public testimony. Anyone present or online that would like to speak to this case? Okay, there's no one present or online. I'm closing public testimony. Petitioner's representative would like to speak again.
So the majority of the reason we're bringing this before the board is not necessarily for the invalidness of it. The majority of the adjoining property owners are in favor of it. No one needs it. The textile is being developed to the north. All the roads around have been developed. So we don't feel like it's a need for anybody to ever develop this as road. And since it being agricultural land and never going to be set aside to be subdivided, there's no reason to have an additional road there as well. So that's the majority reason it's been brought to the board. And the invalidness is just kind of another, icing on the cake. Like, hey, we believe we've proved, or we can tell that we can prove it. We'd rather not have to go through that course. We'd rather go through you guys and just have it vacated. So that's, any other questions for that?
Okay, no further questions. Thank you. Can I get a motion from the board? Oh, sorry. Go ahead.
There we
You're
go.
on.
My name is John Davidson. I'm petitioner's son. I just want to give a little bit of background this whole 300-acre parcel was originally platted or deeded at the same time years and years ago, 40 plus years ago. The reason that we're going through this process is that we, in the course of trying to reorganize some of this farmland and put more of it into use, we discovered through accident that this easement was here. We didn't know it was here, partly because there's no evidence that it is there. Our neighbor here, there is no easement there on his side. This is just woods, virgin woods. So the easement doesn't connect to anything here. And given the roads that have been built in the Aspen Ridge subdivision, there's no purpose for the easement anymore. Between the roads that have been built here and the Texile extension that will be connected up here, apparently in the future, there's no, there doesn't seem to be a purpose to the easement. Now we're going through the vacation process because we went to the borough and the borough staff and worked with them and talked through this and said, well, what should we do? And they said we could do a quiet title, we could go through the vacation process, or we could bring a lawsuit and have a judge do it, because those were the options. And so on their recommendation, we're going through this process of bringing this before the Platting Board and going through the vacation process. We'd rather not bring a lawsuit and go through that process. Our understanding is that this would be the easiest way to vacate a relic from the past that really has no application to the current state of this area, these properties and the development around it. It's hard to tell, maybe looking at a map or looking through a sheaf of papers, what the scenario is here. But the reality is the easement doesn't connect to anything and couldn't connect to anything without some sort of eminent domain process that would enable it to be extended out to this Engstrom Road here. So I'm just giving you that for a little bit of background as to why we're doing this at all and why we didn't just do a lawsuit. It's because we were sort of advised that this would be easier and cleaner than doing a lawsuit, and so that's why we're doing this, and hoping not to really, as your attorney said, bring up the issue of the validity. We have plenty of evidence and had conversations with many staff members here in the legal department and in many of the other departments that this easement, when it was created back in the 80s, wasn't valid. It was created by Rocky Goodwin, who didn't own the property. But rather than litigate that, we thought, well, let's just vacate the easement, since it doesn't connect to anything. It's not needed any longer. And none of the property owners, who are the folks in this Aspen Ridge subdivision, I went door to door myself and talked to as many of them as I could find, and none of them object either. So that's just for your consideration. Thanks.
Thank you.
There was one more point we did want to mention too in the process that they were speaking of, that they were trying to reorganize the property through 40-acre exemptions. We performed an as-built and found that they have a shop that was built, or barn, that was built too close to that easement. And when that was constructed, there was no knowledge, no one in the whole area knew that there was this easement, as none of the previous property owners dedicated it. So it was kind of just slipped in there without any property owner's knowledge. And then construction happened. And then going through this process is when they found out that there was a setback violation to that easement. So that's a little bit of that history there. So.
Okay, thank you.
Yep.
Mr. Ashenberg.
Sorry, there was some reference to the legal department taking a position that this thing's invalid. I disagree. Whether or not this thing is valid is something that, one, is, and the petitioner acknowledges, is not for this board to decide. And two, it would necessitate filing, in my opinion, a quiet title action, or in essence, asking the judge to determine the validity of this recorded right-of-way. So again, I would not assume that this thing is invalid. We don't know. Maybe they're correct, but again, that's not for this board to decide. It would take a Superior Court judge. Thank you.
Thank you, Mr. Ashenberg.
My name is Harry Davidson. Couple things. When the interconnective plan, long-term plan, was created, it would connect Palmer Fishhook with the section line which Ingstrom runs north and south on. At that time, there was no subdivisions in the area. There was only farmland. Very different complexion than what we have today. There were no roads. And so I could see where the borough would say, well, we're going to need something someday back here in this area where there's nothing. And now there is, Ingstrom is being connected, Texile is being connected. There is extensive road work done in subdivisions going north and south through that whole area. It's very different now than when that the interconnective sort of plan was put in place. So the need for that is not the same as it was 20, 30, 40 years ago. And again, like the good lawyer said, it's not a issue of the validity. We didn't even want to bring up the issue of the validity of the right-of-way done by Rocky Goodwin all those years ago, who never owned the property. We're simply going through a vacation process per rules written by the borough. We would like to vacate that because it's not necessary. It's not doing anybody any good, and it doesn't connect to anything. So that's all we're doing. We're simply asking to go through the borough process of vacating that right-of-way.
Thank you. Any further discussion? No. Can I get a motion?
Madam Chair, I move to approve the vacation of the public use easement granted on tax parcel B3, section 15, township 18 north, range 01 east, Seward Meridian, contingent upon staff recommendations 1 through 7.
Can I get a second?
Second.
Discussion from the board.
So there is, you mentioned some kind of road plan is in place to use this right away, whether or not they do or do not will use it. So there is a plan in place to use this right away, correct?
Yes, through the chair.
Yes.
The official streets and highways plan, I believe, was updated in 2022, so fairly recently. It does identify this as an east-west connection between Ingstrom and Palmer Fishhook.
Thank you.
Question. How does that plan address the lack of connection to Ingstrom on the west?
Yeah, so the official streets and highways plan is, the intent is to have an efficient road network that has connectivity and safely and efficiently lets vehicles travel from one place to another. And so it sort of forms a grid. So a lot of these rights-of-ways are not constructed and don't have easements. It is a vision for what the future road network could look like, and it sort of guides, our bond packages and our long-range transportation plan. Now, that can be amended if the petitioners wanted to work with me and an assembly member. We could amend that official streets and highways plan, but that is a recently adopted document that is part of our comp plan.
was lack of actual interest here. They have to get it somehow.
So, yeah, so when we plan for road projects all the time that don't have all the easements that are necessary, and that's just part of the process is to go out and procure the necessary easements.
Mr. Liebing?
Yeah, well, I certainly understand the petitioner's reasoning and desires to have this removed, but given the fact that this is what appears to be a valid right-of-way, and it's part of a master plan, I can't support a platting action that would basically supersede all of that. I think that there are more appropriate avenues should the petitioners want to take a legal action or challenge the validity of it. But that's not, again, that's not for us to decide. So I can't support this vacation.
I agree. Further discussion? Amanda?
I would speak in favor of the vacation. Again, maybe just me, but I don't like the government saying I want this and I want this and I want this and I don't need it yet, but I'm going to hold it. And clearly we have Texel Drive as a connector, and clearly the development of this neighborhood to the south is never going to use that easement. All of their driveways are Wolf Creek Road. They all have access. And so I don't think the petitioner should have to go to court and pay lawyers to vacate what is probably an invalid easement because we don't need it. And it doesn't connect. We would have to take more real estate from whoever owns the adjacent property to get that connection to Ingstrom. So this board is supposed to decide if we want to vacate it if we don't need it, right? And we don't. I think that's pretty clear. And I think that's all they're asking. This is ag land too. And so right now they can't be broken down into 40 acres minimum lot size. So you have maybe 3 people using that for their access to their home indefinitely. Even if the ag board decided to go down to 20s, you still have a very minimal number of people that will be using that. So all you're making is a speedy shortcut behind all these people's houses and up on these farms. And again, one large parcel to the north, you have a major connector that is part of a current plan. I like what the petitioner said about 40 years ago. Yeah, the government says we might need this, we might need that. But now the development has come through where it doesn't sound like any of the people on those lots would appreciate this road in their backyard. And it doesn't sound like any of the farmers would appreciate that road either. So where the plan might have a road thought out here, they have thousands of those roads out there that are being developed around, and in those plans become invalid because the development and the need of the people builds around it. And so that's what I think we have here today. The development and the need of the people has excluded the need for that, and we'd still have to take something from somebody to get that connection, whereas to the north on Texel we don't. And so I believe the roads are there already for the need that exists today or potentially in the future. So I would speak in favor of this motion.
Just to express my point of view, I think right now the borough, to build proper infrastructure for everyone that lives here, needs to keep hold of all land that it now has any right to whatsoever, and we have no business giving it away.
Yeah, I'm in agreement with you on that. And the mere fact that we're sitting here today makes it valid. And like the attorney said, it's not up to us to decide whether or not it's valid or invalid. But I believe it's valid because we're sitting here today and it exists. So I have to look at it in that aspect. And I did not help develop the 2022 document. And if there's a road on there that we might be using in the future for the borough, for the public, if that was removed from that document, then I'd probably vote yes today. But it's on that document. I'm sitting a hard no.
I look at here, we have a Thomas Martin that says he likes using the easement, and then if the road is built, it'll give another way out of the neighborhood, which is matching with what was stated here, and I'm agreeing with Chris here that I don't think we should go down that road.
Thank you. Any further discussion? Amanda?
I think if I remember our attorney's comments, this would be similar to where potentially the petitioner could request continuation indefinitely. And maybe a board that is more friendly towards vacations of public lands might come around someday.
Mr. Strawn, how would that work?
I do not know the answer to that.
Mr. Ashenberg?
I'm not sure I heard the full question or understood. You're saying they could apply in the future.
I guess my thought is, could we move and vote to table this indefinitely? And they could petition a future plating board that might be more friendly towards vacating public lands.
John Ashman, Deputy Borough Attorney, through the chair to Board Member Salmon. I think it would have the effect of a denial if you just move to postpone it indefinitely, and because the time constraints for approving plats don't, in my opinion, apply to the vacation of interests and rights of way, so forth. I don't see a legal prohibition to doing that, but it really has the effect of a denial. But, it's legislative, so I don't disagree that, if the plating board has a different makeup in the future and there are board members that are more in favor of getting rid of public streets, and this was dedicated as a public road, well, obviously, if they're more favorable to that, then they may have a better chance in front of the board.
Thank you, Mr. Ashenberg.
Sorry, if I could just quickly, John Davidson, the son of the petitioner. The reason we're trying to do this is that we have two large ag parcels here. This 75-acre parcel up here and this 60-acre parcel. And these are ag parcels that were part of a program in the Mat-Su Borough in the 70s. And there's covenants attached to these parcels. We've been told by the borough that the borough basically never revokes these covenants, and that these ag parcels that were part of this specific program in the 70s basically always stay attached to these parcels. And that's fine with us, because we are using these parcels as ag parcels. We have livestock, we're growing crops, we're trying to put more of this land into production. Consistent with the requirement that we only have 40-acre or more or larger parcels, we're trying to replat these two parcels into three parcels. For infrastructure reasons, for all kinds of reasons of getting the land into more of this forest into production. Part of it already is in production along the south part here. In the process of doing that, we stumbled upon this old recorded easement from Rocky Goodwin back in the 80s that we have reason to believe was not valid because he never owned this property. We were told that we can't replat from two contiguous plots into three contiguous plots until we get this easement dealt with, because the barn that we built encroaches upon this easement we didn't know, nobody knew was there. That's the reason that we're before the plating board, because in talking with staff, they said, well, why don't, the easiest thing would be to go through the process of vacating this old easement. So that's what we're doing. That's the context of all of this. That's why we care at all to vacate this easement, because we're trying to, and we have an application before with the plating office to replat these two properties into three ag properties. But we have to get this issue solved first because our barn encroaches upon this old easement, which is just a patch of woods that doesn't connect to anything. So that's all I'll say. Thank you for your time.
One more bit of information I wanted to share too was there is overwhelming public support for this vacation, as you've seen by the 10 of the owners, 12 total, but 10 actual owners that are in support of it. The property owners to the east and west, and the larger parcels are in support of it. They just didn't write back. So if the plating board is not favorable to this, we would ask for a continuation and maybe have the rest of the public come in to give their testimony and support for this action. So I just wanted to give that as a, we would ask for a continuation if you guys were leaning negatively towards this. So, thanks.
Thank you. Mr. Liebing.
In my opinion, once again, the solution that you're asking for is not the appropriate solution. Because from a plating board standpoint, there are documents, public documents, that state that this corridor is important, and there are ways to change that public document, and there are ways to challenge the validity of this, both of which I absolutely believe what you're saying, that it's questionable validity, that it's there to begin with, and that the transportation document needs to be amended, and both of those things can happen. I don't think the plating board should be in the business of giving away this right away until those things are changed. So I'm not in favor of postponing it until we can clarify that stuff. So that's my 2 cents.
Thank you, Mr. Liebing. Ms. Krieger.
I would just like to add to what Mr. Liebing was saying. We can't really vote on vacating something that may or may not even exist. So until some certain other questions are answered for us here, whether it exists or not, or if the borough has plans for this thing, I think we should table this for a while and just not make a decision today on this until we get some more questions answered. And I know I'm supposed to make a motion to get some questions answered, but yeah, I just don't feel comfortable today making this decision.
I believe we have to say yay or nay today. Do we not?
We don't have a motion yet, but I would make one
There is a motion
We do
on the
have a
table.
motion
to,
approve.
can I make a motion to amend the motion and table this time indefinite?
Mr. Strawn.
To be clear, table indefinitely generally means to kill it, and it just goes away. And I guess my question for staff, in cases where somebody requests a vacation and this board denies it, does it still go to the assembly or does it just die there?
I believe it ends here, but if you give me just a moment, I will double check my code book.
Just once again, the mere fact that I'm looking at it in front of me shows me that it exists. It's not our privy to argue with what the plating is right here. It's up to a judge to decide whether or not this document is a valid document and whether or not these people have the right to give it away. As of right now, this is recorded. I'm looking at a right of way on this plat right here. So I actually motioned to vote, and there's other avenues to take care of this, and there's always could bring it up again next year when more information's given.
Yeah. I believe that the way in which you want to do that, Chris, is to call the question.
Call to question.
Call the roll.
Wait, what are we voting on? Are we voting to continue it indefinitely?
We are voting on the motion that's on the table, which is to approve the variance.
So my amendment didn't get a second.
So is there a motion to table indefinitely? Okay, so that needs to be,
That means to be second, so. Amanda, okay, so Amanda has a motion to table this. Is there a second? Seeing none? That fails, right? Yes.
yes. And then if the question's been called on the main motion, then the question is there any objection to calling the question? And if there's not, then there'll be an immediate vote on the main motion, which is to approve this right away vacation.
Okay, so is there an objection to approving the motion, the main motion? No? I said it wrong?
Yeah, so you have to ask if there's objection to calling the question.
Is there an objection to calling the question? My apologies. Seeing none. Okay, now we're on the main motion. Is there objection to the main motion? Yes.
Yes.
Okay. Madam Clerk, when you call the roll, please.
Microphone.
Well, yeah, we're gonna say yes or no. So,
Yes.
do you approve or deny the motion? Yes.
The
We are
motion,
approving
motion is
this
to
plat or
approve
not.
To approve
it.
his request.
So you can
The
vote.
plat.
Yes would be to approve it. No would be to deny it.
Okay.
When I call your name, please state your vote. Plotting member Shavetta,
No.
plotting member Liebing,
No.
plotting member Gilson,
No.
plotting member Salmon,
Yes.
plotting member Trexler,
No.
plotting member Krieger,
No.
plotting member Burtz,
Yes.
we have 5 in opposition. Plotting members Shavetta, Liebing, Gilson, Traxler, and Krieger. There are 2 that said yay. Plotting members Salmon and Burtz. The motion fails.
Thank you, Madam Clerk. Okay, moving on. Okay, so the motion has failed. We have no other items of business. Plating staff comments. Mr. Strawn?
Thank you, Madam Chair. Last time I got to sit in this seat, there was a request for a presentation on the role of the comprehensive plan and Robert's Rules of Order and the Open Meetings Act and all these things. I have been working with Fred on developing a presentation, which we hope to bring to you in the upcoming months. So have not forgotten about that.
Thank you.
We do have, 7 cases for the next meeting.
Really?
So just a heads up, August 7th may last a little while.
7?
There are 7. Let me talk to our planning
you do?
director and see if we can get some snacks.
That was not good news. I don't think I've ever seen that many in one meeting. Okay. That was staff comments. Board comments.
Those were some good cases.
Quickly, just for like everybody's information, and correct me if I'm wrong, but I think anybody can record anything on anybody else's property, whether they own it or not. They're not checking down at the recorder's office. So
Well,
when
I
you see
think
them,
they gave it away though. They gave away land that they don't own is what they're claiming.
yeah.
These
So what I'm
people
saying
did.
is, when you hear those check your title commercials on the radio and all that, they're not just talking about title theft. This kind of thing.
It could be it could be invalid, but it's not up to me to decide that. It's the guy down the
Madam
road in
Chair,
that black
Madam Chair,
robe.
if I can interrupt
Mr.
here.
Strawn.
I don't think it's appropriate to talk about that case now that the
okay.
petitioner's
All right.
just left. Even though it's not quasi-judicial in nature, I think this type of conversation should be reserved for when the petitioner is there and the public is paying attention to that. And I would recommend doing comments one at a time, just calling out the commissioners one at a time. So.
Thank you. Okay, so you're telling me to do roll, go down the line? Yeah. Okay. Mr. Leaving, any comments? Mr. Burt's, any comments?
Nope, no comments.
Ms. Krieger?
No comment.
I forgot your name, forgive me. Gilson, Mr. Gilson.
No comments.
Mr. Shavetta?
I have nothing.
Ms. Salmon? My comment is I'm glad it's over. All right. Seeing no further comments, the meeting is adjourned at 2:37.